Hi, Cora Stack here, Dr. Cora Stack. I'm trying to explain the constitutional blind spot, and let me use this phraseology here: too early, too risky, too late. That kind of, think of it like that. So, my name is Dr. Cora M Stack. In this video, I want to explain a concept I'm developing in constitutional law, the constitutional blind spot. A constitutional blind spot describes a situation where a constitutional safeguard appears to exist on paper but cannot be effectively invoked, examined, or remedied in time to prevent or correct an alleged constitutional defect. The reason I'm trying to I developed this concept is to try and explain what happened to myself the day before the presidential election in 2025, where I found myself in a position, and this concept explains why I found myself in this a rather embarrassing position, to say the least. In simple terms, a right may exist, a court may exist, a procedure may exist, a remedy may appear to exist. This is what Constitution is all about. It's about offering the opportunities of citizens to challenge constitutional defects in decisions, political decisions, or other decisions. And so on paper, all these laws exist, or rights and remedies and courts and procedures and so on exist. But if the legal system cannot act before the relevant democratic event becomes constitutionally final or practically irreversible. For example, the president, by Article 12, once elected, cannot be removed, irrespective of whether there was any defect in the constitutional process, nomination or election process that led to that election situation. That's the law in Ireland. So this is the constitutional blind spot. This is especially important in time-sensitive constitutional cases such as elections, nominations, referendums, emergency powers, or other public decisions. In these cases, timing is not a minor procedural issue. Timing may determine whether constitutional protection is real or merely formal. Political processes often move quickly. Nomination deadlines, particularly when we look at elections, for example, nomination deadlines close, ballot papers are prepared, elections proceed, results are declared, constitutional finality may attach, as per Article 12 of the Irish Constitution. Legal systems, by contrast, may move more slowly. There may be procedural steps, listings, pleadings, jurisdictional arguments, institutional caution, judicial restraint, balance of convenience reasoning, mootness, ripeness, justiciability objections, cost risks, or allegations of abuse of process. Each of these elements may appear legitimate when viewed separately, but the constitutional danger arises when they operate together in a sequence. A case may be said to be too early before the event. It may be too risky or too disruptive during the event. It may then be said to be too late, or mootness is the word often used after the event. This is the time trap. Too early, too risky, too late. You can see the timing of the too early period, the too risky period, and the too. Let's see how this is handled, or allegedly has been handled. At no point is there a clear and effective moment at which the Constitution issue is fully examined and corrected before it becomes irreversible. This is where procedural reframing becomes so important. Procedural reframing occurs when a serious constitutional issue is redescribed as something narrower, more technical, more personal, or far less constitutionally significant. A structural constitutional question may be reframed as a personal grievance. A constitutional defect may be reframed as a timing problem. A democratic process issue may be reframed as a political complaint. A serious public law challenge may be reframed as an administrative inconvenience. A good faith constitutional challenge may even be characterized too quickly as abusive, excessive, disruptive, or procedurally improper, or a personal grievance. Of course, genuine abusive process is a serious matter, and courts must be able to protect their procedures from misuse, but the concern I'm raising is fundamentally different. The concern is that a serious constitutional issue may be procedurally reframed before it has been fully examined or examined in time. And if that procedural reframing occurs at the very last possible moment of timely constitutional review, the concern becomes even more serious. This is not a minor procedural matter. It is a profound constitutional and ethical concern. In a constitutional democracy, citizens must be able to trust that serious constitutional questions will not be displaced without being misdiagnosed, a little bit more than misdiagnosed, minimized or reframed so late in the process that there is no meaningful time left to challenge the reframing itself. If a judgment, procedural framing, or dismissal comes only at the final point before constitutional finality attaches, the citizen may be left with no effective opportunity to correct the record, appeal the reasoning, or obtain a meaningful review in time. And the citizen in a constitutional challenge is acting on behalf of the citizens, not themselves, in a constitutional challenge. This is deeply troubling. It may leave the constitutional challenger in an impossible position. The person has come to court asking for urgent constitutional protection, but the legal response may arrive so late that the very remedy sought is no longer available. The issue is not only legal, it is moral, it is constitutional. It goes to the dignity of the citizen in a constitutional democracy. A citizen who brings a serious constitutional issue in good faith should not be made to feel that the constitutional system exists only in theory. This should not be left with a formal process that arrives too late to matter. They should not be procedurally reframed out of constitutional protection at the very moment when protection is most urgently required. If this occurs because of ordinary delay, institutional caution, procedural complexity, or excessive deference to political processes, then constitutional law must recognise the danger and prevent it from reoccurring. If, in any case, it were ever shown that such reframing was deliberate, unfair, or done in bad faith, then the matter would be even more serious, because procedural reframing can cause real harm. It can hide the constitution issue from view. It can damage reputation. It can cause financial loss. It can create legal exposure. It can deprive a citizen of an opportunity. It can remove a meaningful chance to participate in a democratic process. It can leave a person publicly diminished, humiliated, while the structural constitutional question remains unanswered. This should concern everyone who cares about constitutional democracy, not just in Ireland, but elsewhere. The purpose of constitutional law is not merely to protect institutions from disruption. It is to protect citizens from constitutional wrongs. It is to ensure that power remains accountable. It is to ensure that rights are not theoretical. It is to ensure that procedures do not become barriers to justice. It is to ensure that constitutional safeguards can be invoked, adjudicated, and remedied in time. This is why I describe the constitutional blind spot as the gap between formal constitutional protection and practical constitutional enforceability. If it is the interval, I'm looking at it as the time interval. It is an interval where constitutional correction may still be necessary in theory, but becomes unavailable in practice. In election cases, this is particularly or especially dangerous because once the democratic event has passed, constitutional finality may attach. In the Irish presidential context, Article 12 creates a particular finality, as we know, around the presidential election. Once that finality attaches, the election cannot simply be reopened or undone in the ordinary way. So this means the critical constitutional moment is therefore is before the event becomes final. If the alleged constitutional defect is not examined and corrected before that point, the opportunity may be lost. This is why a Supreme Court case examining such a matter retrospectively faces a very serious constitutional question, which I am trying to bring to the Supreme Court. Even if the past event cannot be undone, clearly, the court can still recognise the existence of the constitutional blind spot. it can explain the constitutional risk. So this is what I'm asking the Supreme Court to examine in my case, which has been adjourned. And it's very, very technical, so I'm trying to assist the courts. I'm sure they're not listening to this, but, the various legal people understand what... I think they, the members of the Supreme Court, if they're listening to this, would understand it. I definitely think they wouldn't have an issue understanding it. No, I think they'd yeah. I think I'd be a good lecturer for these people. So that's the story about the constitutional blind spot, and so they're my points, and I understand it because it has taken me months to find out how I got into this place on the eve of the presidential election, with all the newspapers saying that my case was entirely baseless. So the question for the readers was that procedural reframing, and what were the consequences for the citizens of Ireland of that happening to a challenger representing not themselves but the ordinary citizen on behalf of the state.